for those Dire Straits fans for you out there, this presentation is for you. It is entitled Money for Nothing and Your Grief for Free. Over the next 45 minutes or so, Gary and I are going to be discussing 4 primary topics. The first is doing a very sort of high level recitation of the COVID related federal programs that have been enacted since the beginning of this pandemic. We're then going to transition into the abuses that have been captured so far and been reported primarily from the Department of Justice, as well as other federal agencies. Then we're going to unpack the federal government's response to the abuses that have been found so far, as well as highlight sort of what we see coming down the pike here in the very near future. And then we're going to conclude by highlighting a few takeaways that we have distilled from the abuses that we've seen so far, as well as understanding what the regulators' priorities will be going forward. So we're going to start off here. Gary's going to give a quick rundown of the federal programs that are available, and that's going to set the stage for the more substantive part of the presentation, which is going to be discussing the abuses that we've seen so far.
So Clayton and I are trial lawyers, we're litigation lawyers, and so we usually work off chronologies, and I've developed a little chronology as to how we got here. You'll remember that on January 19th, 2020, the Chiefs played the Titans in the AFC Championship game. The Chiefs won 35-24, and the wind chill was about 2 degrees, and Clayton and I were there with his son and some other friends. January 19th. January 31st, Health and Human Services declared a national health emergency. On that same day, President Trump issued his famous China travel ban. And a couple of days later, February 2nd, the Chiefs played the 49ers in Miami at the Hard Rock Stadium and beat the 49ers 31-20, winning the Super Bowl. Because of the AFC Championship game, I got what I think are mostly COVID symptoms. And for that Super Bowl, I was in bed and didn't actually watch it. I was in Colorado in bed with, I'm just sure, COVID symptoms. I was sick for over a week and gave it to my family, came back, gave it to Clayton and others. It wasn't until February 11th, 2020 that the World Health Organization told us what it was. It was COVID-19. On March 6, 2020, Congress started acting quickly. They came up with the Coronavirus Preparedness and Response and Supplemental Appropriations Act to start moving toward vaccine research and development. And 5 days later, the World Health Organization declared a pandemic. Another week later, Congress pushed out the family's first Coronavirus Response Act, paying additional paid sick leave and unemployment benefits. California and Illinois started the stay-home rollouts in March of 19. Kansas came along in March 30. All the other states joined in the stay-home rollouts. And finally then, on March 27th, we got the well-known Coronavirus Aid, Relief, and Economic Security Act, the CARES Act, for the $2.2 trillion. That's where we got most of the money for Project Warp Speed, about $10 billion, and that started rolling out in April and May of 2020. So that's the basic chronology. Under the CARES Act, as you'll remember, and as other people have mentioned, we had a number of programs. The first one is the Paycheck Protection Program, which applied to all small businesses. Our law firm, probably every medical practice, everyone participated in the Paycheck Protection Program, $367 billion of loans that did not have to be paid back. They expanded employment benefits. They had direct payments to families. Clayton, I don't know how many payments you got. You got a bunch of payments, right?
I have a lot of kids, so probably.
Yeah, a lot of kids. You got a lot of payments. We had a whole bunch of money going to hospitals, healthcare systems. They gave some money to larger businesses called the Main Street Lending Program. Airlines, other contractors that were shut down got money. The Department of Defense got money for personal protection equipment. which, by the way, they didn't use for PPE. They sort of used it for whatever they wanted to use it for. That's the DoD. And then the state governments, state and local governments got $150 billion. I don't know if you'll remember, but that was pretty controversial as to why they needed coronavirus money. Some calling it, a state and local bailout. In any event, the next program was the Provider Relief Fund. This also came out of the CARES Act. And in the CARES Act, we had about $100 billion to reimburse providers for increased expenses or lost revenue. And they also they expanded the Paycheck Protection Program, had additional enhancements. I actually tried to read these bills, PL 116-136 and PL 116-139. I don't recommend reading those bills. The Provider Relief Fund was first called the Provider Relief Fund in the Third Act. It wasn't the first time they got money, or you all got money, but it was the first time we called it the Provider Relief Fund. And you'll remember, and you probably participated in two different kinds of payments. The first one was just a push out to anybody who had billed Medicare in 2019, and they were going to provide services for possible COVID cases. It didn't have to actually be an actual COVID case. It's just the possibility of a COVID case. So it was pretty easy to justify the money. You had to have Medicare fee for service in 19, and you had to be spending money on diagnosis and care of possible COVID cases. Then, of course, you had the targeted distributions, which were much more verifiable. You had to have so many COVID admissions if you were a large hospital versus a small hospital, and that sort of thing. There was also an expansion of the SBA Economic Injury and Disaster Loan Program, another loan program you didn't have to pay back if you met the conditions, kind of like the Paycheck Protection Program. They added billions to that, expanded it, and that they expanded it to hit most of the nonprofits with these forgivable loans. You were probably already familiar with the Accelerated and Advanced Payment Program, AAP, whereby if you had an emergency, if you had a disruption, you could apply for advanced payments on your billings, and you could get up to 3 months. They had to be paid back, but didn't have to be paid back for a year. And so that was another program that was available. So that's your basic outline. You've got your Paycheck Protection Program, your Provider Relief Fund, your advanced payments, and your economic loans coming from the SBA, the emergency loans. So then you have, whenever you have that much money flowing, of course, you have opportunity for program abuse. And Clayton and I looked at a lot of these that you can Google them. You can go to the DOJ website. You can go to the OIG websites. You can look at the OIG yearly plan. There's quite a bit of guidance on what they're doing. We just heard this morning about the audits that are going to be starting. I thought the easiest way to do this, to start off, would be to do just a case study on what we call the low-hanging fruit. I'm involved and have been involved in some criminal cases where you can just describe, all you can do is say it's low-hanging fruit. I know we in the healthcare industry worry about ticky-tacky stuff, and we really get into the weeds when we have whistleblowers who report what's going on from the inside. But when it comes to the Department of Justice, if they don't have a whistleblower, they're just looking usually for just plain old fraud. And again, we had these 4 programs. And so this Dr. Joseph, I found particularly interesting. He's was in Highlands Ranch, Colorado. My son used to live out there. So I was a little bit familiar with the area. And I thought Dr. Joseph was just a perfect fraudster to highlight the ability to move this money around. Also to highlight the idea that when you move money around like this, you can get caught pretty darn easily when you're moving it electronically. So unless you have piles of cash and are putting it under your bed, when you're moving money electronically from account to account to account, the feds are pretty good at tracking that. So Dr. Joseph had Spring Medical Associates. He got in trouble and gave up control on January 29th, 2020. Remember where we are. The national emergency was January 31st, 2020. So he gave up control on January 29th. He remained an employee of Spring Medical Associates until April of 2020. And he opened up his first unauthorized bank account on behalf of Spring Medical Associates on March 27th, 2020. So at that point, he was an employee, but not in control and should not have been opening up accounts. He opened up 2 more accounts in October of 20. So we have the emergency declared, we have the push out of the money, and the first thing that Dr. Joseph applied for were the advance payments, the 3 months of advance payments. And remember, you had to have billed Medicare within 180 days. You had to be not in bankruptcy. You had to be not under medical review or investigation, and you had to have no delinquent Medicare overpayments. And so he applied for those. It just so happens that Springs Medical Associates qualified. So as we said, he was no longer in control. He submitted his AAP request form on March 29th, and lo and behold, on April 7th, a week later, Navitas sent the money to the official Springs Medical account, which he then unloaded, transferred to his personal account the next day. So he took the $86,000 from Navitas and then took a little bit extra. And in the indictment, you'll have to follow with us on these various statutes. The first indictment was for basic healthcare fraud, fraud of a healthcare program, and that's 18 USC 669. These criminal fraud statutes are in Title 18. And again, from just recent experience and some past experience, it's interesting how the government will take the same set of facts and then divide the facts up into different counts with different statutes so they can do stacking. When you stack, Class E felony on top of another Class E felony on top of a Class D felony, you start getting all the penalties that go with those 3 infractions, same set of facts. You also, when you get to the sentencing, the federal sentencing guidelines, you start off with like a level 24 and then another level 24, another level 24, and then you start stacking all of the sentencing guidelines, which makes your, when the statute A says you may be, 10 years in jail and $100,000 fine, and the next one is 5 years in jail and $100,000 fine, or another 5 years in jail. I mean, they start stacking these things. And so same set of facts, 3 different statutes. This is the first one. They charge him under the defrauding a healthcare benefit program. Again, these are for the AAPs. These are for the first 3 months of payments that he applied for and got, and then moved to his own account. The company was entitled to the money. He was the wrong person submitting the application, and he stole the money from the company. Still charged with defrauding a healthcare program because the money came from a healthcare program. The next one was the Provider Relief Fund. So you'll remember that the Health Resources and Services Administration pushed out a whole lot of money for anyone who had the 2019 Medicare billings, and were providing testing, et cetera, for possible COVID. They hadn't been terminated. They weren't excluded. These are things that HHS could tell just from running their computer programs. And Medicare billing privileges not revoked. So they could just do a quick look. See, did you have Medicare billings? Yes. Were you terminated? No. Were you excluded? No. Were your privileges revoked? No. Do you swear that you're going to use the money for possible COVID patients? Yeah. There's probably a COVID patient that's going to walk in. I'm probably going to use the money. So the Spring Medical Clinic, they qualified. You have to then, to retain the payments, you have to use them for related expenses or lost revenues attributable to COVID-19. It has to be used again for the possible or actual COVID-19 cases. And like And like PPP, or unlike PPP, they don't go exactly to payroll costs and mortgage interest, but they're very, very similar. And so the provider relief funds and the PPP loans, some of those things are overlapping. You cannot apply, you can't use the same rent payment to get a PRF fund and a PPP fund loan. You can't get the money from PRF and from PPP. You have to declare that that my expenses are not being covered by another program. So other than that, they were qualifying. So Springs Medical met the criteria, and HRSA sent them $32,000, and they wired the money, and then he took the money and wired it to a family member account. And again, it's not that the practice didn't qualify for the money. It was that the person who ended up with the money didn't use it for the right purpose, and it was money from a U.S. agency. This is a different statute. This is 641. So it's not a healthcare fraud. It's from it's public agency fraud, and so it's money from a different agency. Again, there's no real point in this. It's from it's healthcare fraud also, but they're just stacking. So they have the first statute abusing a healthcare program, the second statute taking money from a healthcare agency, which of course is what he did. And then finally, he decided to dip into the Paycheck Protection Program. And he actually filed a loan application and put down the monthly payroll expenses, which he had known, the number of employees. And the lender processed, whatever lender he chose, processed and transmitted the loan to SBA. The money came in. And he opened up an unofficial Springs Medical account for that money to be deposited into. And he had a false PPP application because it wasn't actually the Springs Medical account. It was a fake one and a fake person. Nevertheless, he applied on June 24th. On June 29th, 5 days later, $180,000 came from into the unofficial Spring Medical account. You kind of wonder why somebody wasn't looking for the lock boxes, but they weren't. The money was just flowing at that point in time. And he went to Jackson Hole and did some home improvements and bought some cars and did some other stuff. Third statute he violated was 18 USC 1343, which is taking money by its wire fraud in connection with a public emergency, publicly declared emergency. And so again, they take this one set of facts and they divide it into three parts, and now he's violated three criminal statutes. So those are the sort of the low-hanging fruit. You got the wrong guy getting the money, not using the money, violating those three statutes. And so with that, I'll turn it back to Clayton for another interesting case.
Fantastic. Thank you, Gary, for that informative information. For those of you that are still watching, at this point, you should be seeing poll 6. So please check the appropriate box. Alternatively, you can put the code that's in the lower right-hand corner of this slide into the chat box, and Adrian will make sure that you get credit for it. So continuing down this, I guess, parade of horribles, another case that has already been prosecuted or is in the process of being prosecuted is United States versus Pedro Hanesian. And this case, like most of the others, involved taking advantage of the PRF and EIDL program. And as you look here, and this is going to be a common theme as we start seeing these cases percolate up, is that a lot of these cases, the local U.S. Attorney's Office is involved to some degree. And so you're seeing different charging theories. So as you saw with Gary just a few moments ago, there are a number of 18 USC statutes that were being used to prosecute these cases. There is some redundancy across the different cases, but there is differences, as you'll see as we go through the additional programs, as well as charges that have stemmed from just general bad acting in the COVID context. So here, again, this is a PRF case, and kind of to me, the walkaway point is, and I think you're going to start seeing more of these cases fall out as this auditing process begins, as Alex was discussing this morning. that there were basically two eligibility requirements for this program. First, that you weren't excluded from participating in the federal healthcare programs, and then also that your Medicare billing privileges had not been revoked. And so, as you can see with this case and then the two that follow it, there have been, even before this auditing process began, there have been cases that have been unearthed. OIG does not answer as to how these cases came about, but presumably, they're able to do this internally and figure out which of these two requirements aren't met. And I think going forward, we're going to probably be seeing a slew of civil monetary penalties, which we'll discuss here in a few more minutes, sort of what that is. But I think these PRF cases probably present a litany of low-hanging fruit instances that I think we're going to start reading a lot about in industry publications about how people had not qualified for the PRF program, had not repaid back the money, and now are entering into CMP settlements. So again, just scrolling through here real quick, and it's just not one particular group. We have home health agencies. We have an urgent care center. They just a number of folks that had gotten money that they presumably were not entitled to. One thing to note with the CMP program is that in entering into that, no one is making an admission, rather they're just basically settling these cases. So we don't necessarily know a lot about the underlying facts or even what had happened. We do know, though, that they were willing to separate with some amount of money, which we've outlined here in these slides to kind of give you a flavor for what we've been looking at. And again, a lot of these things, you highlight these facts that cars were bought or additional homes were bought. These are all additional facts that the government would like to use in its sentencing of these various defendants. And so that's why, and when you read these handouts from the Department of Justice, why they typically note what this money was spent on, because usually those are aggravating facts that they would otherwise rely on if these things are not settled. These cases would go forward to trial.
I think it's going to be interesting, Clayton, is that when you get into these criminal cases or the false claims cases with the government, a lot of these large payments were made on 2-page applications, but that's not the way they will charge you or investigate you. They will go to the regs, they'll go to the statutes and the regs, and they'll go to every little ticky-tacky thing that is said in each of those, and they'll pull every one of them out and allege that you knew at the time you did these things, because you attested to all these things that are in the regs, not just what was on the application, but everything that was in the reg. And I'm dealing with the government right now on that. I mean, they're not even embarrassed by it.
And that's a really good point, Gary. And that's one we'll be closing with a little bit later on is, and we discussed this morning briefly with the Azir case, of these sort of what we call sub-regulatory guidance, and whether or not parties can be held to rules that did not go the formal rulemaking process. And right now, which we'll touch upon at the very end here with the takeaways, there is a sort of a state of confusion with respect to how that sub-regulatory guidance will be used, especially under the new administration, as they've repealed the brand memo, which a number of folks in the industry had been relying upon for thinking that sub-regulatory guidance would not carry much weight going forward in the FCA type cases that could be coming down the pike. So we touched on the additional cases for the, for the PRF. Again, just highlight at a high level here as we're getting short on time. Some of the additional cases, as Gary had said, with the PPP, we highlighted this case, the Dinesh Shah case. If you have a few minutes, this is a very interesting case, $25 million. And it's kind of, I discussed earlier, the government's MO of putting on what specific things this money was spent on here. It was spent on home, jewelry, luxury vehicles. And I believe he ended up getting, I think, over 130 months for his participation in the PPP program. And we're starting to see bigger cases rolling out with multi-defendants. So basically cross-pollination from different government agencies talking to each other. And as they do so, I think we'll probably be seeing these cases on a larger scale than maybe we saw at the beginning, like with the Dr. Joseph and him being kind of what they would view to be a lone wolf. I think as the regulators are able to speak more together and to kind of see trends and data, we're going to start seeing these more multi-defendant cases being brought going forward. Here's another case. Again, this is in the healthcare context, but it's pretty similar to what we've seen just in general with PPP.
I love this one, Clayton, because I love the way the guy was hiding the fact that he had two different companies. One was Rye Associates and the other was Rye I Associates. I mean, that's pretty clever.
It sure seemed at first. I don't know what his thought would be now with regard to the cleverness of that setup, but it certainly worked for a period of time. And it looked like he was a frequent flyer, as it had noted in the DOJ entry that he had prior healthcare fraud charges for surgeries not performed. So basically, a lot of these, as Gary alluded to at the very beginning, these programs enabled a lot of folks to rear their head, and now the government is sifting through these cases and attempting to get back the billions of dollars that have been spent sort of apparently erroneously by people who had abused these programs. Here, transitioning a little bit, it wasn't just with the federal money that was handed out. There were also other actors that were just attempting to take advantage of the situation that we were in. Here, Billy Joe Taylor was actually one of the first cases that was brought, and this was a situation in which they were getting beneficiary information that they were then using to request tests that were never necessary, and there was also a kickback scheme that was involved. And as you can see there, tens of millions of dollars were involved, and was just an example of someone taking advantage of the situation. Likewise, there's a case out of California where it was basically an allergy testing company that basically, in addition to this, they were engaging in a kickback scheme to get providers to order tests that weren't actually necessary for their patients. And then when COVID came about, they quoted the CEO as describing this, or describing what they do as basically being a pastry chef that had made strawberry pies with their previous allergy test, but now we're providing strawberry and rhubarb pies. And so basically touting the ability of his allergy test kits to also test for COVID, which was false. And so just again, another example in the healthcare context in which folks have attempted to take advantage of the situation. And as the regulators have caught up, they're starting to prosecute them for the abuses that they have found. This one I thought was interesting to note, just realizing that there are a number of ways in which people could abuse or take advantage of others. And this is the vaccine card example. From what I could distill from the DOJ reports that I have read, there's really kind of three different classes of vaccine card activity. One being an employee just steals the card and then attempts to sell it on the black market, which they've actually caught at least one nurse and one pharmacist doing this. Then there was a homeopathic doctor out in California that was falsely filling out the cards, basically saying her homeopathic remedy was the same as one of these approved vaccines, which it was not. And then third is just sort of the ordinary counterfeit card situation. And one thing that's kind of interesting, and this kind of touches upon a point Gary had been making, is I had put the different theories that the various local U.S. attorneys' offices in a particular state have been charging these types of cases with. And as you can see, they're kind of grasping for different types of theories. And as vaccine cards become more prevalent and potentially necessary for different facets of our life, I would not be surprised to see some sort of new federal law coming down that would specifically touch upon these fraudulent vaccine cards and hoping to sort of stem that practice.
So we've always had kickbacks, and we have these 523 Holdings was providing telehealth providers with the Medicare beneficiary information if they would agree to allow their labs to add testing, cancer and CV genetic testing, just plain old unnecessary services. Same kickbacks to patient brokers. We've had this for years, and they were bundling with COVID-19 testing. I think everyone thought that if it had COVID on it, nobody would ever notice. And this one I just threw in just for fun. So you have to have pre-authorization. I had to have pre-authorization for my surgery about a month or two ago. But I guess with COVID, they were just they're just overriding with COVID codes and said, you know, and doing away with pre-authorization. So it was a sort of an antidote for everything. So anyway, just some other friendly fraud cases.
Now, transitioning now here to our third point that we wanted to discuss in our time that we have here today, and that's the federal government's response. And what we wanted to do here, I mean, obviously, as Gary said at the beginning, what we do a fair amount of is dealing with white collar issues that pop up. And so each one of these actors on the right-hand side of the screen, you know, we've had the varying degrees involvement with over the years. But what you're starting to see collectively are the formation of a number of different task force units being stood up that are specifically tasked with identifying, using, you know, different metrics, different data tools, basically mining for these fraudulent activities that they're seeing over and over again, and then basically bringing to bear their specific background in whatever industry that they're in. And so you look at some of these folks on the right-hand side, and they may seem like strange bedfellows, but through these various task force and fraud units, strike forces, they are basically hand in hand, which is going to be leading to one of our main takeaways here is going forward is that, you know, just based on, I guess, the size of these programs that were rolled out, the dollars that were spent, and I guess the collective firepower that these individuals have, we're starting to see a lot of cross-pollination. And when you're reading these DOJ newsletters or issue alerts, they're describing, and it seems as if the folks that are involved are increasing. I think historically, you know, the local U.S. Attorney's Office, so here it'd be the U.S. Attorney's Office for the District of Kansas, they might be working hand in hand with HHS, OIG, but now we're starting to see other folks get involved. And as Gary said, you know, one set of facts may have 3 different federal crimes. And so the way, if you have mail or wire fraud, that's how you're starting to see the FDIC, you're starting to see the US Postal Service, you're seeing a number of different actors joining in. And I think just based on, again, the size of these programs, we're going to see going forward a lot of this collective firepower being used to basically identify and prosecute these cases that they have identified in the years that have followed from the disbursement of these funds.
You'll see them that way, and you'll also see them borrowing each other's people. So you might have a VA OIG inspector visit you or your people, having nothing to do with the VA. So depending on everyone's workload, they share their cases with one another. So that column on the right, we have dealt with all of them in the context of healthcare. We've dealt with every single one of them: postal inspectors, IRS, VA. I have not dealt with the Secret Service, other than one of our partners here's cousin was a Secret Service agent. I actually have not dealt with the Secret Service in connection with healthcare, but all the rest of them we have. And but I think what you're saying, Clayton, is that now they're using their particular substantive knowledge to investigate these things, so that they're not just borrowing, the IRS and people that are available, or the DEA people that are available. They're actually using their resources as part of these strike forces. And so that's doubling up on what they're able to do. The next slide, I'm sorry to jump back, but we've already talked to you about the Department of Justice. When we talk about the Department of Justice, we usually talk about Washington, D.C. and what they call Main Justice. And then when we talk about the U.S. Attorney in Kansas, they are part of the Department of Justice, but we usually call them the U.S. Attorney. It's not that they're not part of the Department of Justice. It's just it's easier to call the DOJ the Washington people and the U.S. Attorney the Kansas people or the Missouri people, whatever state you're in. With regard to the civil monetary penalties law, as you all know, that's a lot like the False Claims Act. You have a lot of the same sorts of activity that you're not allowed to do. It's just that the OIG is enforcing it as opposed to the private citizens bringing whistleblower qui tam cases. You're hearing directly from the OIG. They have their own set of penalties. I hope you haven't run into them. And then you have the, which is very much like the False Claims Act. Of course, CMS can always terminate your enrollment, and their OIG can always exclude you. Then you have the civil enforcement, the DOJ, which then, remember, the False Claims Act usually starts with a petition by a person that was a whistleblower in your organization. The U.S. Attorney starts investigating it. They send it up to Washington, the DOJ. The DOJ has someone who takes a look at it. And then together, the state U.S. Attorney, either Kansas or Missouri, whoever it is, coordinates with the Washington, D.C. DOJ, and they decide whether or not they're going to intervene and take it over and prosecute it themselves. So that's how all that works. With regard to the criminal statutes, I've already hit that. I just want to let you know that they're here. And so this is healthcare fraud is the first one, and the second one is agency fraud, and the third one is fraud in an emergency. That's 1343. So see how quickly we went through that. Go ahead, Clayton.
Very good. So I guess what I view probably the most important part of the presentation is kind of distilling down our slides here. And as we're seeing, and as Gary alluded to with the PRF program, you know, those are sort of low-hanging fruits in the sense that, you know, they have a program that will be able to tell them, are you excluded? Have your privileges been revoked? And so I think that's why we're seeing those cases to begin with. And as they start digging into these cases, they have a basis, they have a reason to look at these. That's how you're starting to see these mail and wire fraud issues and kind of being stacked on top of each other, because it's sort of the old proverbial, you know, the camel's nose under the tent. Once it's there, we're never surprised to see that additional things come out just because of the fact that, you know, that there's always some sort of regulatory misstep that they can typically find. And so what they're finding here, though, is in addition to sort of these regulatory sort of ticky-tack type fouls, what we're seeing now is fraud on a very large scale, and to the tune of tens of millions of dollars, you know, for different medical entities that are being brought and being charged right now. And so one thing to make sure of is as we're going forward, and Alex talked a little bit about this at the very beginning with the PRF audits and paybacks and things like that, that we're making sure that we're aware of what our requirements are, so that we're avoiding the proverbial camel coming to our tent. Another thing, and we've just touched upon here, was the cross-pollination that's occurring in light of just how large these programs are. Gary had discussed the, you know, primarily what we deal with are the False Claims Act scenarios. And there you have a whistleblower, compliance officer, whatever the case may be, that sort of has their finger on the pulse, and the government has to rely on them, because when you get beyond, you know, do you even meet these program requirements, and you're getting into sort of the more nuanced areas, they rely on a great deal to these whistleblowers, these internal eyes that help them make their case. And then this very last one is one that I've used sort of a culmination of a few points that we've made so far here today, and that Gary had raised earlier in this presentation, is that as we go forward, the government's reliance on what we refer to as sort of sub-regulatory guidance, or these guidance memos that are issued by CMS or other federal agencies to describe what sort of reporting requirements you have or other sort of duties that you have. I think we're really going to start feeling our way through what the Ayers decision, which I discussed earlier this morning, means because we're going to get into, does this require, is this a substantive legal standard, i.e., is this something that affects substantive rights, and is it closely moored to a statute or a properly enacted regulation? And if it's not, I think you're going to start seeing a lot of pushback from folks in the industry against the regulators, basically saying this is not permissible. And so that's something to keep an eye on. And then the second thing to keep an eye on is this DOJ policy, where under the Trump administration, they had issued this guidance called the brand memo, which basically said the department was not supposed to rely on sub-regulatory guidance for bringing false claims. Current Attorney General Merrick Garland has since rescinded that, implying that sub-regulatory guidance is back on the table. And so that interplay between regulators and the Ayers decision, I think, are going to come to head here in the very near future, coupled with the other cases that are percolating up with regard to agencies' reliance on rules that have not been promulgated under the typical rulemaking process. I think it'll make for a very interesting next couple of years. And so I guess the bottom line is, if you find yourself in a situation with the regulator knocking, hopefully you'll go back to this presentation and realize that there are a number of issues that are there that could potentially provide a defense to whatever sort of action you may find yourself facing against the regulator. So with that, Gary and I appreciate your time and for joining us here today.